Discuss what the Constitution says, if anything, about the right to same-sex marriage with two top advocates. Leading conservative lawyer Ted Olson, who scored a big victory at the Supreme Court for same-sex couples looking to marry in California, and Tony Perkins, president of the Family Research Council. Gentlemen, welcome back to Fox News Sunday. Good to see you both.
Good morning.
All right, so when the Supreme Court takes a case, they set up the specific questions they want the advocates to answer. So I want to read those and then get your reaction. These are the two questions they've posed. Does the 14th Amendment require a state to license a marriage between two people of the same sex? The second question, does the 14th Amendment require a state to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state? Ted, very specific phrasing. What does it say to you about how they're going to tackle this case?
Well, the reason that those two questions were asked by the Supreme Court is because those were the issues in the states from which the four states was Kentucky, Michigan, Tennessee, and Ohio. Those cases came up to the court from those states. Some of those states prohibited recognition of marriages that were lawful in other states. Some of them prohibited marriage between anyone other than a man and a woman. So those were the two basic questions the court was presented with. And it wanted to make it clear, it wanted to hear from the litigants as to those two questions and not a lot of other stuff.
But the phrasing in that first question, does that stand out to you saying, does the 14th Amendment require a state to license a marriage versus saying, does the 14th Amendment give couples, same-sex couples, the right to marry? I mean, it's a bit of a nuance, but it kind of was a red flag for some of us who watched this stuff.
Well, I didn't put too much weight on that because the issues that have come up through, there's four other federal appeals courts that have decided that states can't prohibit marriage between persons of the same sex. And it gets involved in whether states are engaged in the marriage business by providing licenses and then providing laws that give benefits to people that are married. I wouldn't put too much significance on the way the question was phrased.
Yeah, and they've normally a case gets an hour. They're giving 2.5 hours to this one, so it'll be interesting. All right, Tony, I want to look at where same-sex marriage is now legal across the country. 36 states and here in the District of Columbia. More than 70% of Americans now live in places where same-sex marriage is legal. Have you lost the fight?
Well, keep in mind, Shannon, that only 3 states have the voters actually voted. Two-thirds of the states, people live in states where the voters or the legislatures have affirmed the natural definition of marriage. So we're hopeful that the court will side with the American people on this, the majority of voters who have been very clear in the last 2 decades that marriage is a union of a man and a woman, and that they'll side with the American voters and not with a handful of judges. I mean, most people don't want lawyers and judges running the country.
But sadly, they do in many cases. No offense. All right, let's look at Justice Anthony Kennedy because everyone's going to be watching him. He has had a number of opinions and decisions that have been very friendly to same-sex relationships. He's talked about the dignity of those relationships and the children being raised in those homes. But he's also said a lot about states and their rights to define marriage. I want to read you from his 2013 opinion. This was striking down DOMA, the federal ban on benefits and recognition flowing to same-sex couples who are legally married in their states. He said this, in talking about New York making its own decision to permit same-sex marriage, he said, these actions were without a doubt a proper exercise of its sovereign authority within our federal system, all in the way that the framers of the Constitution intended. And then last year, in a case that involved a measure passed by voters in Michigan with respect to banning racial and gender preferences in public hiring and education, he wrote this, quote, it is the right to speak and debate and learn, and then as a matter of political will to act through a lawful electoral process. The respondents in this case, the people who are challenging the Michigan measure, said they insist that a difficult question of public policy must be taken from the reach of the voters and thus removed from the realm of public discussion, dialogue, and debate in an election campaign. Ted, Tony brings this up, that in numerous states, voters did go to the polls. So why is this discussion, this language from Justice Kennedy, different in the context of same-sex marriage?
Well, in the first place, I'd like to make one point with respect to what Tony Perkins said just a moment ago. There's 10 states where the legislature or the people have voted to authorize same-sex marriage. So that's quite a number in and of itself. But the Supreme Court again and again has said that it's its responsibility to decide when the Constitution trumps the will of the people. Justice Kennedy held for the court, striking down a Colorado measure a number of years ago that discriminated against gays and lesbians. He voted for the court and wrote the opinion for the court, striking laws in Texas and laws throughout the United States that prohibited private same-sex conduct in the privacy of home. And he wrote the opinion for the court in the decision striking down the legislature's overwhelming decision to enact the Defense of Marriage Act. So ultimately, the reason we have a Constitution, the reason we have separation of powers, the reason we have the 14th Amendment is to provide the courts with the opportunity to override the will of the people when the will of the people leads to discrimination against a segment of our society.
But the difference here is that this is not recognized as a fundamental right. This is not deeply rooted in our history. We're talking about something that's unprecedented. In less than 2 decades, we've had state after state go to the polls and people express themselves. This is not how we reach broad social consensus over major issues like this. I mean, as evidenced by what's going to take place here this week, the 42nd anniversary of Roe v. Wade. The court said it was going to decide this issue in 1973. It has not. It will not decide this issue if it imposes a one-size-fits-all scheme of marriage on the American people.
I want to say one thing about that. The United States Supreme Court 15 times over the last 120 years has said that marriage is a fundamental right. It involves
but not same-sex marriage.
It never once in any of those cases did it say that it had to be between a man and a woman. 15 times it said it was a matter of privacy, liberty, association, dignity, and respect for the individual. That's what the Constitution
Well,
is
Ted,
all
let me
about.
ask you about this Roe v. Wade point, because Justice Ginsburg has said publicly that it went too far too fast, meaning legalizing abortion across the board instead of allowing it to play out state by state. Many are making the same argument with regard to same-sex marriage, saying that if you get a sweeping decision here, it's actually not going to help you. It could hurt, because it seems that Justice Ginsburg is suggesting that pro-life forces were mobilized and motivated by Roe v. Wade.
Well, in the first place, in 1967, the Supreme Court struck down laws prohibiting interracial marriages, striking down the laws in 16 states. Today, we don't even understand that we could possibly have prohibited same marriage between people of different races. The president's mother and father couldn't have been married in Virginia. They would have been guilty of a felony. Overwhelmingly, now, young people particularly support the right of individuals to get married to the person that they love. The American people now are 55 to 60% in support of same-sex marriage. People recognize that this is an important right. It hurts gay and lesbian people to discriminate against them, and it does no harm to heterosexual marriage to allow those people to marry the person that they love.
Let me ask you, though, Tony, because I talked to, and I'm sure you've talked to some civil rights leaders who don't like the comparison. They don't feel it's appropriate for them, not some of them.
There you had a man-made barrier keeping the races apart. Here you have judges attacking a natural bridge that brings the sexes together. And if we take down the state's rights to define marriage for public policy purposes, I mean, if 2 people who love each other can get married, I guess Ted's okay with the story out of New York Magazine this week that an 18-year-old daughter wants to marry her biological father. I mean, are you okay with that?
Are you all of a sudden interested in what you read in New York Magazine, for heaven's sakes?
It was on Fox,
I mean,
too.
it's very easy to say the sky is going to fall. We're now talking about something that's permitted in 36 states, or 37, depending on South Dakota last week, and the District of Columbia. No harm whatsoever has been done to heterosexual marriage as a result.
That is not true. Religious liberty has been placed on a collision course with sexual license because of a handful of unelected judges and lawyers. The American people have a right to speak on this. They have. The court should respect the voice of the people.
Well, it'll be 5 votes at least, and we'll see which way they go. Gentlemen, good to have you both here. Thank you so much.
Thank you.